Okay, so thank you for the introduction. My aim today is to give you an insight into a real-life NHS whistleblowing case from a doctor's perspective. I'm grateful to have been given an extended session, but I'm mindful that that gives you the opportunity to get bored stiff by my voice. So I've got some videos that I'm going to use, and hopefully I'll be able to finish up at the end. If there's some questions, however tricky, I'll be happy to deal with them. If you have some questions. So I have been a claimant in a long-running whistleblowing case that's been going on for 8 years. I'm a junior doctor, and I think, and it's been a tricky experience, and the experience has had many twists and turns over the last 8 years. So I suppose a question to a conference like this is, why does that matter? Why does the way a whistleblowing case plays out in court matter to a conference like this and to culture in the NHS? Now, I would say that the way these cases play out, and perhaps in particular the way my case has played out, as it's been fairly public and high profile, is the message it sends. Firstly, to NHS staff, it gives them a message about their chances of being treated properly and fairly if they raise concerns. But also, it's not just NHS staff it sends a message to. It sends a message to NHS leaders as well. If there is an NHS leader, or perhaps a whistleblowing guardian, sorry, a speak up guardian, is considering whether to support a whistleblower, and perhaps if it's a particularly thorny issue, you know, the way these cases play out gives them a sense of their likelihood of getting support from the NHS machine and being treated properly and fairly. Lastly, the message I think these cases send is to NHS leaders and lawyers. It's what the system will let you get away with if under pressure you choose to go down a road. And so all of those points have the potential to send a really, really good message that will nurture the culture we're all working towards. Or conversely, they have the potential to send a really toxic message. So that's why I think that's really the message I want to say. I mean, I could leave it there, but I've got a presentation. So my experience is I come at it from 4 perspectives. So firstly, as a frontline clinician, just yesterday, and perhaps the first 2 hours of today, I was working in a London A&E department. So I get it. I get the NHS front line. So I think anyone engaging with these issues has to know the nitty-gritty of NHS care and has to know what the front line is like. Because any kind of solution to this tricky problem is going to have to be a practical one. So that's the first perspective I bring as a frontline clinician. Secondly, I've been a litigant in an 8-year multi-respondent whistleblowing case. Now, you do not know what that is like until you've been there, I can assure you. And I have been that junior doctor as a litigant in person on 1 hearing against 3 top QCs. And in contrast, I've known the might more recently of trade union support with the QC of my own and a top solicitor. So it's been a roller coaster of different experiences. But I do believe that that gives me an interesting perspective when compared to my frontline A&E experience. And thirdly, through circumstances, I have ended up becoming a crowdfunded litigation. For my own case, I crowdfunded £300,000 to have it litigated, and for other doctors, I've crowdfunded even more. So in a way, I've been more successful for others than I have been for myself to crowdfund their litigation. My most notable case that I crowdfunded for was a Dr. Baragava, which was a case where a junior doctor was convicted for gross negligence manslaughter, and through a crowdfunded litigation, we were able to successfully challenge the GMC in the Court of Appeal. And she is now back working as a consultant. So she was struck off and convicted of a criminal offence. And that has been reversed through the power of crowdfunded litigation in the public interest. So the last perspective I offer is I'm a normal person. I have a family, I'm a dad, a husband, a brother, a son. And I think that's always worth remembering when we get into these difficult healthcare situations. Everyone's a human being with a family or a life. And the patient, the lawyer, the doctor, and I think that's always worth remembering. So hopefully running through this presentation, you will see those 4 perspectives. So the plan for today, I can't hope to go through 8 years of litigation with all of you guys, and I'm not going to try to, but I'm going to highlight some tactics that have been used against me over the 8 years. And then when I go through them in a little bit more detail, I'd like us all to be mindful about who maybe decides such tactics. Senior clinicians, trust managers, executives, solicitors, barristers, and obviously there's these arm's length bodies like NHS England, and you probably all know more about them than me. And in a case like mine, because there's 2 respondents, that's all of them times 2. And then I want to go through what we've done, my side's response, which started as me, a junior doctor alone, and then that's evolved into a junior doctor with 4,000 crowdfunders and now a trade union. So we've been able to do some things in response to the NHS's tactics. And then I want to focus on the potential consequences of really a war between me and my supporters and the NHS establishment in litigation. And that's played out publicly for 8 years, and the effect that has had on culture, on staff, on lawyers, on managers. And I have some thoughts about that. And then hopefully I want to end with some possibilities for the way forward. So maybe these cases don't have to run this course in future. Hope that's okay. So what is my whistleblowing case about? Well, at the heart of the whistleblowing case is an intensive care unit in South London at a trust that was reorganised once one of its predecessor trusts went bust, South London Healthcare. So the protected disclosures centre on the nighttime resourcing of an intensive care unit regarding staffing, training and supervision. And I say the situation there was linked to 2 deaths. So that's at the heart of the case. And I would say the NHS response has been to conceal the reality of that situation and to damage me and destroy my career. Of course, the NHS say they've done nothing wrong. So that's essentially the whistleblowing case in a nutshell. The first 4 years of the whistleblowing case involved the NHS arguing all junior doctors below consultant grade out of whistleblowing protection by attacking their employer status to ensure the case was never heard. And they were successful doing that for 4 years until they were defeated. And then 4 years after lodging the claim, I got a final hearing. So far, so good. But then in 2018, during the hearing, the case suddenly settled. And the last 4 years has been about what the NHS has chosen to say publicly to the press and to MPs about the case and how it's settled. So that's 8 years of litigation that's cost the taxpayer £1 million, and still after all of that, there's been no judgment on the facts. Last month, there was a 16-day hearing, and we are awaiting a judgment on it. And it was interesting for very many reasons that I'll go into. But of note, what made it interesting to many was the fact that one of my witnesses was the former Health Secretary, Jeremy Hunt. Now, we have come close after 8 years of litigation to finding out to actually having a fact-finding process on this situation. But I must emphasise that this has taken 8 years and cost the taxpayer £1 million to get to a point where we might have a judgment that is usable for all parties on what actually happened in this case. So why did this happen? Why was it so painfully long, and why did it cause so much aggro to just progress a whistleblowing case? So what did I actually need to do to win a whistleblowing case in the UK? Well, because I mentioned in my question to Jonathan, the Hill Dickinson lawyer, that because whistleblowing law is an employment law, it means that it only protects employees against harm from their employers. So if the person that does the harm falls out of that relationship, or the person that experiences the harm falls out of that relationship, UK law has no answer to that. So the first thing you have to do is prove that you're employed by somebody. And you'd think as a junior doctor, that wouldn't be quite as hard as it was. Not 4 years, 200 grand hard. So that's the first thing you have to do. The second thing you have to do is prove that what you said contained information that you reasonably believed. Now that's different from an opinion. And so or an irrational opinion. So you can see at one end, and there's a spectrum there. You can see one end of the spectrum is cold, hard facts that are supported, and the other end of the spectrum is someone really believing something in good faith that's really quite flawed, and the facts don't really back them up. And you can see when you're testing whether there's a reasonable belief on that spectrum, one end of it's very easy and the other end is more tricky. But the good faith can run through legitimately in all of those circumstances. But you can see it's a massive chink in the armor, one end of that spectrum in an employment tribunal. So in summary, you have to prove your disclosures have information that you reasonably believe. The next thing you have to prove is detriment. Well, that's obvious, but you have to do it within quite strict time limits. And then the thing that a lot of claimants struggle with is proving that whatever detriment was linked to the protected disclosures, either that they failed to prove their disclosures contained reasonably believed information, or that there is another narrative that comes forward that isn't the protected disclosures that explains the detrimental activity if detrimental activity has occurred. And then the last thing is all of this doesn't come cheap. Even if you are able to prove everything that I've just gone through, your average employment tribunal claim costs between 30 and 50k if you're represented. Now, in my case, it costs £360,000 is what I've paid in legal fees. And that's before the BMA trade union took up the case in 2019. So you're already, alarm bells should be ringing about why has it cost so much in my case. And the 700k in 2018 paid by the taxpayer should also raise eyebrows. But even away from that, in a normal case, you have the figure of 30, 50k, which is certainly beyond the reaches of most NHS staff to essentially advance their right not to be detrimentally treated for raising legitimate concerns. So there's a lot of barriers there for a successful claim, which probably explains why less than 3% of these cases succeed. Actually, if I go back there, so after summarizing what you have to do to win, you can probably start guessing about tactics that could be used to resist and succeed for the NHS respondent in a whistleblowing case. Now I will go through these in more detail, but I'm just going to run through them. So I mentioned the attacking the employer status so the case doesn't need to be heard. Attacking the reasonableness and validity of the protected disclosures, essentially making out the staff members irrational, making a fuss about nothing. And then there's attacking personal and professional credibility, mudslinging. False accounts of meetings and dialogue, concealing, destroying evidence, and then the use of litigation tactics like cost and regulated threats to water down the case, to induce settlement and to force publicity. Misleading the press and MPs, this is a particular one to my case on how it's settled, and then satellite litigation, which explains those figures of, whistleblowing cases don't need to cost £1 million. So what is often done is satellite litigation on points are taken up by the NHS to force claimants down a road to make it more expensive, more hearings, more paperwork, etc., etc. So as I go through these in slightly more detail, I want us to be mindful of who sanctions, who decides that these sorts of tactics are worth pursuing. And I mentioned the fact that there's the clinicians, the non-clinical managers, there's the executives, there's the 4 or 5 NHS panel law firms that exclusively do this kind of work. In the thick of litigation, you then add barristers to that mix, and then there's arm's length bodies that I must say I don't understand as much as I'd like to. And then there's sort of the actions of regulators and tribunals, which permit certain things to happen in certain circumstances. So this are all things, maybe when I go through these in more detail, that we could consider, because I obviously don't know the answers to these questions. So I would genuinely be interested in people's feedback. So I mentioned the fact that becoming a crowd-funded litigant has meant that I've been able to respond to these tactics in ways that maybe are unique. So starting with crowdfunding. Now, on the face of it, crowd justice is about money, about getting small amounts, large numbers of people to give you a small amount of money to fund your case. But it's only partly about that. Crowdfunders give you so much more than money. They start buying into the case. They start reading documents. They start writing documents. They start writing to their MPs. They start writing to the press. They start attending hearings. And suddenly, overnight, I had 4,000 people that knew the facts of my case. They knew the evidence. And so that puts an enormous amount of pressure on decision makers well, you'd think it would put an enormous amount of pressure on decision makers to make sure the decisions are logical and take account of all of the evidence. So that's what I would say is the main strength of crowdfunding, in addition to the obvious of funding your claim. I have benefited from expert witness evidence, guidelines, and serious incident reports to show that that the protected disclosures that I raised were very serious, very evidence-based, and completely backed up by evidence. Unfortunately for me, it took me 8 years to produce 2 consultant anaesthetists as experts. And then the thorny issue that I will deal with later on false dialogue in formal meetings. Now, rightly or wrongly, because I had instances of my dialogue being ridiculously fabricated, I started to covertly record formal meetings just to catch them out. And the simple answer is I did, and I showed this. But it's something that should be considered, I think, as a last resort, and you've got to be able to justify it. But there's nothing like it. If you have a false damaging record of a meeting and you can show what was actually said, it's very helpful. Employment tribunal, unfortunately, similar things can even happen in the employment tribunal, where not quite so blatantly, where the person producing the record produces a record that reflects that which they would like it to reflect, and they don't let a little thing like what was said or what actually happened get in the way. And what we used at this last hearing, we funded the transcribers of the High Court to come to the Employment Tribunal and produce an official transcript. So every word that was said by the judge and everybody by Ministry of Justice approved transcribers. And that is a solution to get round a systematic problem in the Employment Tribunal of records, transcripts not being kept of hearings. I mean, you may find that quite surprising that in every employment tribunal there isn't a transcript of what was actually said. There's judicial notes that actually are private documents. If you ever want them, they always have the option of not showing you them. So those are some of my responses to the NHS tactics. One of the fruits of my case going into the public domain and being widely understood is the level of witnesses that I was able to produce at this June hearing. One of them was Jeremy Hunt, the former House Secretary, which you might think is quite interesting for a junior doctor to have him on his witness list. And that, I would say, reflects how serious the issues are in this case. And in addition, I had Sir Norman Lamb and 2 very brave consultant anaesthetists to sort of make clear to the Employment Tribunal the seriousness of the situation. They were obviously struggling to see it for 8 years, and this sort of backup shouldn't actually be needed, but is. And if there's something that I've learned is, forgive me for thinking this, but it's certainly my perception that the system can really care less what I think or say about anything. And so it shouldn't be the case. A junior doctor should be able to say something, and if it's factually sound, they should be able to be listened to. But obviously that is not my perception. So I've needed these more powerful people to come and say what I've been saying for 8 years. And that might be something that has come from my crowdfunding, which meant that if I hadn't had it, the truth would never have come out, which I think is very worrying. So I'm going to go through in more detail the tactics. So tactic one, arguing the nation's doctors out of whistleblowing protection back in 2015 during a junior doctors' industrial dispute. Now, I'm going to show you a video of a discussion in Parliament where this was described.
Junior Dr. Chris was a very prominent example of someone who blew the whistle and was treated then accordingly. He raised particular concerns about staff ratios, but then lost his job. Tribunal action, which followed, resulted in a lengthy, and I consider a wholly unnecessary legal battle where Health Education England were effectively seeking to remove around 54,000 doctors out of whistleblowing protection by claiming that they were not the employer. 4 years and hundreds of thousands of pounds later, they eventually backed down and accepted they should be considered an employer after all.
So I think in the heat of the junior doctors' strike in 2015, NHS Health Education England thought it would be a good litigation strategy to attack my employer status and essentially render me employerless, in the hope that it would break the weak whistleblowing law we have country sufficiently so that the hearing would never take place. Now, this is why I bring up the point of who decided such tactic. Now, that's a really clever idea for an employment lawyer. But at that point, that's all it is. Where was the NHS manager coming in and saying, well, nice idea, but that's crazy. We cannot argue the nation's doctors out of whistleblowing protection just to stop Dr. Day's case being heard. Where was that voice? And that is a key thing here. There was a vacuum of healthcare leadership, and the employment lawyers of Hill Dickinson were running the show. And that's really why I asked that question. And that this is a News at 10. This is me on News at 10, ITV, explaining to the nation how Health Education England and Hill Dickinson argued the nation's doctors out of whistleblowing protection to stop my case being heard. It caused a stir, as one would expect. And it also meant that there was a lever for me to start a crowd justice campaign, because it's so obviously wrong. And their argument involved claiming that Parliament had intended that doctors below consultant grade would not benefit from statutory whistleblowing protection. They actually said that in court. And there were journalists in the public gallery that heard it, which is why it was caused such a stir. And this is where I think I overemphasize this point, because who decided this? And the answer is an employment lawyer that was not given sufficiently good instructions from healthcare leadership, in my opinion. I don't know that for sure. It could be that a healthcare manager decided that, but it seems very unlikely they would have. But believe it or not, that's not the worst thing about that. And I just returned to the video of Parliament where Sir Norman Lamb goes into more detail about how they did it. And believe it or not, how they did it was even worse than what they did.
I'm very grateful to our friend for giving way. Is he aware that contract, which was between Health Education England and trusts, which demonstrated the degree of control that Health Education England has over the employment of junior doctors, was not disclosed for some 3 years in that investigation. And it was drafted by the very law firm which was making loads of money out of defending the case against Chris Day. When I raise this with Health Education England, they won't give me a proper response because they say the case is in there. Does he agree that this is totally unacceptable and that it smacks of unethical behaviour by the law firm to make money out of not disclosing a contract that they drafted themselves? Thank my Honourable Friend for his intervention. I think he absolutely highlights a really important. Earlier, Junior Dr. Chris Day was a very
Yeah, so Health Education England and Hill Dickinson, that's the reason I sort of gently, and you very gently grilled the Hill Dickinson lawyer before me, hid a commissioning relationship that Health Education England had with every NHS trust in the country, controlling £2 billion worth of healthcare budget, governed by contracts the firm Hill Dickinson drafted from disclosure, and then made court submissions that were fundamentally opposite to what was clearly apparent on what was contained in these contracts drafted by Hill Dickinson that were withheld from disclosure. And this is an example of these commissioning contracts. So essentially commissioning contracts, and this is the one from Barts Health. As you can see, I've used paint to highlight the fact that this one's worth £79 million. These are not the contracts you forget about. If you've drafted a contract worth £79 million, you don't forget about them. And if you've drafted 220 of them, you certainly don't. So how do they explain their actions? And you see Sir Norman Lamb says in Parliament, which is recorded in parliamentary transcript, they don't want to give a response. So Parliament has asked for a response, and Health Education England and Hill Dickinson won't give one. And so Sir Norman went and made a complaint to the legal regulator. And that's all the way back in 2019. And so you might ask what's been done about it. And the answer is absolutely nothing. So that's tactic one, attacking my employment status. So tactic two has been, if we come back to what I've needed to win the case, attacking the validity of my protected disclosures. Now, the pictures you see are Dr. Smith and Dr. Hamachi. These are two brave consultant anaesthetists that agreed to provide statements to expose how serious the safety issues were in the intensive care unit and the link between two deaths to the protected disclosures I raised being ignored by the trust. But these two brave individuals came to court in June 2022. So that's 8 years after I raised the disclosures. The position that £1 million of public money is spent defending is essentially that my concerns were a fuss about nothing. And the investigation that concluded that, the NHS Trust paid £40,000 for. And that's another key thing. Is that money well spent? So the evidence from the two consultants came last month was clear. And Dr. Smith said there was a clear and present danger to patient safety. Absolutely no question about that. You cannot get clearer than that. And that was a public gallery full of 70 people heard that, but also knew that for the 8 years prior to that, the position expressed about the same situation in an intensive care unit affecting the 3 London boroughs of Greenwich, Bexley and Lewisham was that a situation that presented a clear and present danger to patient safety, and that position, there being absolutely no question about that being the case, was represented by Health Education England and Lewisham and Greenwich as being completely acceptable. Now, as is obvious, I'm not the only one who suffers from that. There's the matter of the people in the 3 London boroughs that required critical care during that time. And if you bring the relevance of the COVID-19 pandemic into it, whereas things like intensive care unit, breathing tubes and ventilators have become much more understandable to members of the public, maybe even members of NHS management staff, to anyone, the need for ICU has been made painfully obvious through the COVID pandemic. Yet these 3 London boroughs, as a result of the actions on my protected disclosures, were affected by that. How could they not be? And these two consultants went on to say that the conclusions that the NHS spent £1 million defending were completely at odds with these evidence-based principles that I clearly presented in 2014. And it was stated that, quite obviously, that the situation didn't meet basic safety standards, or ignored and smeared you know, so how did they manage to do this? How did they manage to pull the wool over people's eyes for 8 years? It's simple. They just excluded evidence from investigations. So this Dr. Frankel was the most senior doctor in London. He went on the record and said the whole thing that I described was unsafe and totally unacceptable. And then that was just left out of witness statements and investigations. 2 serious untoward incidents involving patient deaths that clearly backed up what I said and also occurred after I said it were just excluded from the investigation. The findings of an entire HE investigation were misrepresented. Serious findings were represented as no concerns. And the stated view of 4 other doctors was withheld from investigations that backed me up. So that all allowed Hill Dickinson and the law firm Capsticks and the various trust people that instructed them, who I still don't know the names of, to pull the wool over people's eyes. But it came at a huge cost, just in monetary terms, £1 million to give that impression to an employment tribunal. And that's just the money it costs. We don't know what it costs other people having this reality concealed from people that might have been able to do something about it. So tactic 3, this is obvious mudslinging, but it's very expensive mudslinging that the taxpayer funds. So false allegations, false accounts of dialogues in meetings. So you can imagine how it was. I was angry and abusive when I raised these safety issues. And obviously when you have things like covert audio, whether that happened or not becomes really obvious. And when I say that, the prospect of covert audio was also very useful for my case, because there was a point where they didn't know what meetings I had the covert audio for. So there was a moment they found out that covert audio evidence was going to be used, and that meant that everyone had to start telling the truth about meetings. And you got into the situation where consultants then started blaming the HR director for falsely recording their dialogue, which may or may not be true. But it shows that it's mindful that clearly I can be criticised. You know, one way of looking at covert audio is how underhand, disgusting I am for you going down that road. But it's the fact that such methods are necessary, I think, points to cultural issues that need to change. I mean, it's easy to attack me, which clearly is a tactic, but we need to be thinking about why such methods are necessary. And then the last thing, junior doctors have e-portfolio, so they have supervisor reports and lots of feedback from staff. And so I had reports from over 30 individuals over 4 years of my practice, all glowing. That was all excluded from investigations. Again, so that just allows, if you're going to do all of those things, if I have to deal with a false account of a meeting, all my e-portfolio being excluded, and then I have to deal with serious safety issues being portrayed as irrational fusses about nothing, you can imagine how the employment tribunal, what the employment tribunal was like. And that's really where this is all heading, is do we want to go down this road with people who raise serious safety concerns? I think I've done this to death. So tactic, it is a separate tactic, but you know, specifically the account of the formal investigation meeting by these management consultants they paid excluded the patient safety content, excluded reference to serious incidents, fabricated my dialogue, having me agreeing to false allegations, distorted things that I said, fabricated concessions from me, and then another example of fabricated anger and emotional stability. You know, I'm confident I can show, well, as you can imagine, that's easy for me to show. Tactic 5, I genuinely cannot believe I'm using these words, but that last June at the June-July hearing, there was a Computer Weekly article, as there were several journalists in my hearing, and they reported the extraordinary events of the 16-day hearing that I most recently featured my case, and it described NHS director getting up at 5. The case was that the NHS director got stressed and got up at 5:30 a.m. and went to the hospital and deleted 90,000 emails just before he was going to be subject to a disclosure order. I mean, you have to read, if you want to, you might wonder how likely that is to be true. I know I couldn't believe what I was hearing or reading, but if you go to this article, it explores that and several other examples of the NHS getting desperate and destroying and concealing evidence. They destroyed the NHS mail account of the director that was the instructing client in the case, and they say that that's been permanently destroyed. So all email communication about my case for 8 years apparently was also destroyed. And you cannot. I cannot believe I'm saying this, to be honest, in a NHS whistleblowing case. And then when it came to my supposedly fair hearing to induce settlement, I was threatened for costs of £500,000, and my lawyers were threatened with their own wasted costs, and were threatened to be referred to the legal regulator about our use of covert audio. And that had the effect of me refusing to continue because I didn't want to risk my health, and doing myself really out and my family out of any chance of justice. Clearly, this all happened in October in 2018, so the public would have also been done out of all the stuff that's transpired at the June hearing. So the reality of the safety issues would have never come out had that been the end of the story. So what happened was the NHS, once they went about these methods of threatening me into settlement and threatening me into making a public statement, they decided to imply to, oh, hang on. No, sorry, forgive me, I've jumped on. Just coming back to cost and regulator threats. Sorry, I was moving on to my next slide because I'm feeling the time pressure. This issue of cost threats is not just an issue with me. This Financial Times article that did cover my case interviewed Shah Qureshi, which is head of a big big national employment law firm, and he remarks that employers and their lawyers routinely threaten costs against whistleblowers to frighten them into dropping their claims or watering them down. So basically, they just use the playbook on me that they seem to use on all whistleblowers in employment tribunal litigation. I don't think there's anything particularly special about what they did to me, but what is special is that they decided to talk about it. And this is basically the reason that we were back in court last June and July. Because of my support on crowdfunding and because the public gallery was full, the hearing where my case settled, it became very obvious the reality of the safety issues and the reality of the NHS response. So when I suddenly threw in the towel and released the public statement saying I believed the NHS acted in good faith, which was not a smart move on their lawyers' part, you pushing for the agreed statement, it became very, very clear to large numbers of people that something was amiss. And the options being either that I sold out the safety issues for a massive payoff, or that I'd been threatened in some way. And once it became established that I hadn't had a large payoff, it became clear that their cost threats must have played a part in this. And so the NHS got defensive and started to say that there were no cost threats, and any indication that there were was untrue. And they said that to the press and MPs. And when saying that, they waived a special kind of privilege that disguises, that conceals, quite rightly actually, I'm not saying there's anything wrong with it, but without prejudice privilege allows people to negotiate settlements. And it's right that there should be this mechanism, but because the NHS managers started talking about it, they waived the privilege and allowed me to waive the privilege as well and tell everyone what actually happened. And they went further and they said, because they started to respond to pressure from MPs and the press, they started to lie about the case. quite remarkably said the case was nothing to do with the ICU and just about ward cover one night, which is ridiculous. They claimed false things about their own investigation, and they mentioned that the cost threats were simply untrue. And then they gave this narrative of my own legal team approaching the other side with the concern that my evidence was untruthful, and that being the real reason the case settled. So these are things that were all the subject of this hearing last month, June, July, and which makes it even more suspicious, doesn't it, that 90,000 emails were suddenly deleted and email accounts were deleted. You'll be pleased to know this is the last tactic. So tactic 8 is failures in tribunal disclosure. So back in 2021, the beauty of having 2 NHS respondents in a whistleblowing case is that they don't compare notes. So Health Education England let slip in an email that they disclosed to me that the CEO of Lewisham and Greenwich NHS Trust had written 18 letters to local MPs that I had reason to believe and were false and defamatory. And it turned out to be right. He did write 18 letters to local MPs and councillors and failed to disclose them. So we successfully obtained a disclosure order criticising the respondent, which has to be the CEO, for failing. I think Judge Kelly says that on the slide, failing to comply with specific discovery obligations. I was pleased about that, as you can imagine, but that was the tip of the iceberg on their failure and concealment and destruction of evidence, as transpired at the hearing 2 months ago, where on day 15 of the hearing, it became clear the scale of the destruction of evidence that had occurred in my case. And the hearing was paused while we got a disclosure order against the trust. And then the next day, we actually filed a motion, well, the American term, which is actually known more, is a motion to dismiss. But it's actually a strikeout application in the English Employment Tribunal. But it's basically to say, look, the conduct of the NHS respondent in this case has been so scandalous and vexatious. They've destroyed all the evidence. The hearing has to end. They have to leave the court, and we continue to, without them, to try and form a judgment on this. And it's quite remarkable to do an application like that. And that's what we did on day 15, after the public had funded 15 days of employment tribunal. I, with British Medical Association support, instructed that application to be made, which is extraordinary. So they 8 tactics. What the picture there is of a war zone. What has been the effect? 8 years, and I think it has been a war. Dr. Day versus 2 NHS respondents that turned into Dr. Day and 4,000 junior, crowdfunders, more, not just junior doctors, and then Dr. Day, 4,000 crowdfunders of the British Medical Association. This has been widely reported in the media, ITV News, pretty much every newspaper, all the big newspapers, Radio 4. It sent a terrible message. Sent a terrible message to me as well, which shouldn't be underestimated. It's a bit demoralizing what I've been through. But putting that to a side, because that's not, you guys are interested in me, I get that. The message this case sends to NHS staff is actually much louder than anything the Whistleblowing Guardian Office can dream up. When you have cases like this and you have the Guardian Office remaining silent and not lifting a finger on them, that sends a message much louder than anything you lot can come up with. And it sends that message to staff. The likelihood that staff will raise concerns has been affected by my case, and that's clear in evidence from social media and evidence we've received from doctors. But it's also affected, I've been told by I certainly won't name them, but I've been told by senior NHS managers that it's affected their confidence in the system too. You know, their chances of being listened to, their chances if they do encounter a very serious issue with a whistleblower, their chances if they support them of not joining the whistleblower graveyard with the whistleblower. They don't have confidence in it. And then there's the effect on NHS lawyers. When you've seen the tactics that I've just set out, because nothing's actually been done about any of those tactics, it puts pressure on NHS lawyers to think, well, this is what I must do to win whistleblowing cases. And because nothing's been done about them for 8 years in my case, it sends a terrible message to lawyers who, I come back to my original point, lawyers are just people, you know, they're people with families just trying to live their lives. And this toxic culture that extends into the legal profession in the way these cases are handled has an effect on them too. And then more widely, it boils down to confidence that patients and staff have in NHS management structures. You might be good, you might be a good NHS manager, but I don't trust you because you might not be brave enough to support me, or you might be a baddie. I mean, how brave do you need to be to support someone in a case like this? Those are all the sorts of questions that are really dangerous questions. And then there's confidence in the regulatory structure. If I do support them, will the regulatory structure or the legal system support me? Will I get justice? Or will it just gang up on me? And will I never get justice? And I think you may expect someone like me to go on about the employee and the junior doctor. But having walked this path for 8 years, I actually see that senior managers and lawyers are perhaps bullied just as much in situations like this. And it's not hard to see why. When you look at a case like this, it can't not be the case, because that's really the way you would explain it. It's probably the most likely way of explaining a director coming in at 5 a.m. and destroying 90,000 emails. I imagine he wasn't in a great frame of mind when he did that. And I think that's probably a really good example of what I'm getting at. It's not just about the junior members of staff. It's about an entire system that needs to change. So the way forward, building on that point, we need buy-in from everybody. The freedom to speak up is about giving people confidence to raise the protected disclosures, which is great if people need a bit of confidence to do that. But we need a plan for what happens when there's a massive cover-up, when there's serious misconduct, when there's whistleblowing detriment. And that's what there appears to be silence on. We like the freedom to speak up, but there's some other freedoms here: the freedom to cover up, the freedom to do flawed investigations, the freedom to hide contracts, the freedom to delete 90,000 emails. And we're yet to find out whether you're free to do that. But if the employment judge isn't as strong as she ought to be on that, that might be the latest freedom to be added to the freedoms that need to be dealt with. And you see, if we're going to deal with things like that, we need buy-in from NHS staff, NHS managers, the lawyers, judges, and politicians to deal head on with that kind of thing. And that's what there doesn't seem to be the appetite to do. And that's what's basically cost me and my family so dear, and actually cost the people who needed the ICU to be safe in South London. So I'm going to rattle through these really quick, just in case there's any questions. So I think this is what would have really helped me: credible and fair investigations. If I can say something objective, like they've lied about the record of the meeting and they've excluded a load of evidence, someone should have listened. I think industry-specific employment tribunals are not geared up for these complex industry cases, and that's true of the financial sector. I speak to a lot of bankers in these sorts of situations. Your average employment tribunal tends to do a very poor job with healthcare and financial cases for obvious reasons, because you've got to have industry-specific knowledge. So I think that would change. And then a pop at the NHS panel law firms. Clearly, the instruction in my case is destroy him at all costs. We must win, do whatever it takes. Just imagine if the instruction was different to the NHS panel law firm. It was find the truth, make the difficult decisions, interview everyone, and try and solve the problem. And we know it isn't that. And that's really what I was going to ask. I mean, Jonathan kind of dodged my question I asked him, so I didn't ask him another one, which is fair enough. But just imagine if the panel law firms wanted to do that, you know, when in a whistleblowing case, they potentially consume the money, maybe 50-50, half I got a Hill Dickinson lawyer to help me, and the trust got a Hill Dickinson lawyer to help the managers, and we tried to sort out the problem, and maybe even leave the employment tribunal out of it. Credible enforcement. If this director goes and destroys 90,000 emails and nothing is done about it, which I fully expect, that's another thing that we're going to pay for. And then there are moves to change the Public Interest Disclosure Act, which I guess I support. And then I definitely support a new statutory body, so a body independent from the NHS to deal with these cases. I mentioned about I've made my freedom point. I won't make that again. There are other freedoms to be addressed. Okay, follow me on Twitter if you want the update on the case, if you're interested.